Good morning. I'm just going to give everybody a few minutes to get signed in. Looks like I've got one more signing in. I'm going to take up the quick matters first, and then I'll get to the lengthier matters in just a minute. The first case I have that looks to be fairly quick is Samantha Keller Vasquez. Ma'am, if you could unmute for me, please.
Yes, sir.
I've reviewed your file, and there's a couple of issues. Your husband signed a waiver that says he wants to sign the final decree of divorce, but the final decree of there's no final decree of divorce. So what we need is the actual document that the judge signs to grant the divorce that has your agreement on the custody, visitation, child support, as well as who's getting what property. That needs to be filed, and your husband's going to need to sign that because his waiver says he wants to sign it.
Okay.
The other thing that I think the other thing I would recommend is looks like there's a typo on the waiver that he signed.
Okay.
And it would be better to clean that up so you don't have any issues in the future.
Okay.
The waiver he signed says that he signed it on November the 9th, but then the notary wrote that he signed it in front of the notary on November 29th. So the dates don't match up. So since he's going to have to sign the decree, you might want to send him that waiver again and have him re-sign that, just so we don't have any issues with that next time. Okay. So I'm sorry I can't finish today, but you're close to being done once you get that paperwork. And if you don't have a final decree, you can get one on the second floor of this courthouse. We have a law library, and you can go in there and tell them you need a form for a final decree of divorce with children, and they'll print that out for you. Fill it out and then have your husband sign it.
Okay. And then once I have him sign it and I submit it, what would be my next step?
Then you're ready to go, and it should take you probably about 3 minutes next time you come in, and we'll be able to grant your divorce.
Okay, thank you.
All the paperwork is done correctly.
Okay, thank you so much.
Thank you. Okay, let's see. We've got Ms. Beckford. I also noticed that this is set for final trial. Is that correct, ma'am?
Yes.
And did you send notice to your husband?
Yes, we're both on.
You got that.
Oh, he's here as well.
Yes, he's here.
Mr. Beckford, is it you that has iPad there?
Yes.
Okay, I'll come back to y'all in just a second. Ms. Beckford, how long do you anticipate for the trial?
Not long at all.
Okay. All right, I'll come back to y'all.
Okay.
On the Shaw matter,
Yes, Judge.
got a couple of Judge Hepperton and I both went through this. I reviewed it in more detail because she was in a hearing yesterday and gave her my opinion on the matter. And she asked me to hear this, but we both feel the same way about it after talking about it. So the issue I have is that y'all can pull out your codes, but 156.006B1 makes it basically the court is to review the four corners of an affidavit to determine whether or not the court should even set a temporary orders hearing. And the appellate cases lock in the four corners of that affidavit. So it could be that there's all this other evidence out there that could potentially rise to the level that gets you where you want to go, but I can't take that into consideration. All I can take into consideration is the four corners of the affidavit that was filed. And to me, that doesn't rise to the level of meeting the criteria of 156.006B1, which is that it significantly would impair the child's physical health or emotional development. And so because the four corners of the affidavit don't get us there, the court is instructed under the family code to deny even having a hearing on it. So I know y'all announced 2 to 3 hours, but really this case shouldn't even be set. The problem we have is the court coordinators don't know that. They're not judges. And so they typically will just set someone once they make a request for a temporary orders hearing. And then the judge comes in and we review it later and we go, oh, wait a second, we have an issue with the affidavit. And so that's kind of where we come down on this. So to me, unless there is additional evidence in another affidavit filed subsequently, or we have some other development in the case, the court is not inclined to grant a temporary orders hearing in this case because it doesn't rise to the level of us being able to have that hearing. Because, and one other thing I'll mention is the law changed a little bit. It used to be when 156.006 first came out, it only applied if you were trying to switch custody. So if you were saying, well, I want to tighten the geographic restriction, I want to make it just Fort Bend County, not Fort Bend and Harris County. Well, in the old days, and I say old days, this is a relatively new law, but we used to be able to have hearings on that. But then they amended the law, and now it says if I'm going to alter or create a geographic restriction, then I'm stuck with this affidavit. So that's the ruling of the court. I am going to make a docket entry that you both appeared, and then I'm going to make the docket entry that just says after review of the four corners of the affidavit, the court finds that it doesn't rise to the level where we can have a temporary orders hearing in the case. Okay, but I want to thank y'all both for appearing. And yes, ma'am.
Just to clarify, I mean, our motion to deny is essentially asking the court to dismiss the modification action, not necessarily just the temporary orders request. So I just wanted to get a clarification of the judge's order.
Well, I understand that too, but the thing is, I think if it's going to be actually dismissing the entire action, that's more of a summary judgment ruling, and that would be something where the other side's entitled to 21 days notice of a hearing and to proffer additional evidence. Because just because I'm denying the temporary orders doesn't necessarily mean I should deny the entire case, because typically it's a different burden I'm dealing with from a temporary order versus a final order. The problem y'all have with this case, though, is it was filed within 1 year. So because it was filed within 1 year of the underlying order, you still have 156.102, which we may take up at a later date because that's when we're setting it for a final trial. But Ms. Fote, I think if you want it dismissed, you would, to me, they're entitled to 21 days notice and to go through all that because they may have additional evidence that I'm not aware of.
Okay.
Okay.
Understood, Judge.
All right. All right. Thank y'all.
Judge, we'll just discuss it with the opposing counsel and we'll see if we can come up with an amicable.
Yeah, y'all can talk about it, and it may be that y'all are able to get something resolved, or it may be that y'all have to do some additional discovery to see what the facts are. But I'm not dismissing anything today. I just don't feel I can have a temporary orders hearing.
All right, Judge.
All right, thank you, Mr.
Thank you for your time.
Ms. Bote.
Thank you, Your Honor. Yeah, we're dismissed, Your Honor.
Maybe we'd be excused.
You are. Thank you.
Okay, thanks.
Thank you.
You may.
Hey, hey, Judge, this is Agent Beckford. I gotta go back to work.
Well, you're in court, and so do we have other cases here as well? I'm taking as many cases as I can, but I'm taking the quickest ones first. And I believe I may be ready to come back to y'all because I think the other case may be lengthy. But you're in court, so if you need a letter from the court that tells your boss that you're in court, you can. The courthouse can give you a letter. But if you leave, we're going to proceed without you getting to tell your side of the story, which I don't recommend because I want to hear from both you and your wife. All right, so just give me one more second. I think I'm getting close to getting to y'all. On the Rowan matter, how long do y'all anticipate for y'all's trial?
I anticipate about 3 hours, Your Honor. Maybe two.
Judge, I don't know why the length and time. All we're doing is determining a debt to be awarded to one of the parties, Judge. I anticipate 30 minutes to an hour on our side at most, Judge.
Okay. All right, I have one other case, which is Beckford.
Go
And
ahead.
that one I think is going to take me probably 30 minutes or less. So I know y'all have a variance of what your time estimates are. But I would like to review your pleadings because for some reason I saw it was set for today on our computer program, but for whatever reason, it wasn't on our docket, which is kind of odd. So I would like to look at your pleadings before I come back. So what I'll do is, why don't y'all come back at, let's do 10 o'clock, and hopefully I'll be close to being ready to start y'all at 10 o'clock. And if we kind of meet in the middle, it may be that we're able to get y'all done before lunch. Okay. But y'all are excused until 10.
Thank you, Your
Okay,
Honor.
thank you.
Thank you, Judge.
All right, on Beckford,
Yes.
Yes.
we're going to get on the record on this. So what that means is there's a machine that takes down everything that Ms. Beckford, everything that you say, and Mr. Beckford, everything that you say, as well as everything I say. So because there's a machine taking down what we say, it's very important that we talk one at a time, because the machine can't take down two people talking at the same time. So the way this is going to work is, because Ms. Beckford filed the lawsuit, she gets to go first, Mr. Beckford. So she's going to be able to tell me what she wants, and when she's done, and you may disagree with some of the stuff she says. You may say, well, that's not true. Don't interrupt her and say, you're lying or anything like that. Just wait your turn. Maybe make a note of it. If you need to write something down, make a note so you don't forget to tell me. But you're going to be able to tell me your entire side of the story as well. Ms. Beckford, when he's done, I'll come back to you and say, is there anything else you want to tell the court after he spoke? And if you say yes and you tell me some more stuff, then I go back to him. And we just kind of keep going back and forth until y'all are done telling me what you'd like to see me do today. And with that, we're going to get on the record. The court's on the record in cause number 19 DCV 263735, the Beckford matter. Ma'am, if you would please state your name for the record.
Jessica Marie Beckford.
And sir, if you would please state your name for the record.
Adrian Lloyd Beckford.
All right, Mr. and Ms. Beckford, if you would please each raise your right hand to be sworn in. Do each of you solemnly swear or affirm the testimony that you're going to give in this cause will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
I do.
Thank you. All right, Ms. Beckford, like I said before we got on the record, since you're the petitioner and you're the one that filed the lawsuit, the law says you get to go first. So if you'll tell me what you'd like to see the court do, and then I'll go to Mr. Beckford as well. But you may proceed, Ms. Beckford.
Well, at this time, I just want the court to grant us a divorce. There's just no going back. It has been a long time and I'm exhausted. I've been trying to get a divorce for some time now, so I'm just done with it. I just want the court to grant us a divorce.
Okay. Let me ask you a couple of questions that I need to hear the answers to, just, and then Mr. Beckford, I'll ask you if your answers would be the same. But Ms. Beckford, did you live in Texas for 6 months before you filed this petition for divorce?
Yes.
And did you live in Fort Bend County for the 90 days before you filed this petition for divorce?
Yes.
Has your marriage to Mr. Beckford become so bad that it destroys the marriage relationship?
Yes.
Is there a potential for the two of you to go back living together as husband and wife if I don't grant a divorce today?
Yes.
No.
Were there any children born during the marriage, Ms. Beckford?
No.
And are you presently pregnant and expecting a child?
No.
You have filed a proposed decree And in that decree, it doesn't list any property. Are you telling me that you two don't have any property together?
Correct.
And so you're asking that whatever bank accounts or credit cards that you have be awarded to you, and whatever bank accounts and credit cards and stuff like that that he has, that he would be responsible for those and awarded those?
Correct.
So there's no real estate, no cars, nothing like that that the court needs to divide up.
No.
Did you purchase a car while you were married?
Yes.
He did.
Hold on, I'm going to Ms. Beckford first. Ms. Beckford, do you have a car that you purchased during the marriage?
Yes.
He did.
Mr. Beckford, I'm talking to Ms. Beckford right now. I'm going to give you an opportunity to tell me everything in just a second. Ms. Beckford, you said he bought a car?
Yes.
Okay, and you know what kind of car it is?
It's a Chrysler 300. I think the year is a 20.
Okay, and you're asking that he be awarded his car?
Yes.
And you need debt on the car?
Excuse me?
And in any debt that he owes on the car, you want him to pay for that debt? Is that what you're asking?
Yes. Yes, that's his car.
All right, so you don't have a car that you bought during the marriage?
Yes, I have a 2011 Hyundai Sonata.
And you're wanting to have that awarded to you?
Yes.
All right, any other assets out there that you haven't told me about that you think you want to be awarded to you or to Mr. Beckford?
No.
Anything further you'd like? Oh, I'm sorry. Do you feel like that property division that everybody keeping their own stuff is a fair division of the estate to both you and Mr. Beckford?
Yes.
All right, anything further you'd like to add, Ms. Beckford?
No, sir.
All right, Mr. Beckford, it's now your opportunity to tell me anything that you would like to tell me as it relates to this case and as it relates to what property you'd like to get and what property you would like Ms. Beckford to get, or any debts that are out there that you want awarded to one party or the other. So you may proceed, Mr. Beckford.
I just want to say this, Judge. We can live together as husband and wife, and I do love my wife. I told my wife that so many times. I told my wife, I will give you anything to make this marriage work. I told her that. I even prayed with her this morning. I said, I just want my marriage. All I ever wanted was you, but all you kept on doing these years while we've been together is run away from me and always had some other man in her ear or always telling me about some other man. And I'm not trying to bash her or nothing. All I want is my wife. I sit up there and try to give her everything that she wants and to have. And she's steady. I mean, she's been wanting a divorce ever since we said we do. And I've been trying to continue provide and continue doing what she wants. And it's steady, nothing is good enough. And she's have this nonchalant attitude like, it's nothing good. Everything I do is not good enough to her. I proved myself. I done everything right. And like I said, we don't have no property. We don't have nothing. But the thing is, I have nothing but love for her. And my heart has always been in this marriage. And the love that she said she had for me, she never loved me. She just loved what I could do. And nothing more. Whenever I didn't come through or fall through, it wasn't good enough. And it was always failure. And she sat there and cheated on me during the marriage while I was out working. I work on the water as well. And that's what I'm saying. But I'm not gonna, I don't have no more to say, Judge. I thank you for giving me the time to speak.
All right, thank you, Mr. Beckford. All right, Ms. Beckford, it's now your chance to tell me anything else that you would like to tell me. It may be that you don't have anything, but if you want to respond in any way, you can. If you do, then I'm going to open it up to Mr. Beckford to tell me anything that he'd like to tell me again as well. Anything
I don't have
further
any-
you want to add, Ms.?
No, because we'll just keep going back and forward. I don't have anything to say.
Okay. Well, let me say this, Mr. Beckford, I understand that you want this marriage to work out, and I appreciate you telling me that. And a lot of times, and I will ask Ms. Beckford one more time just to make sure that her heart is set on this, because in Texas, even though one party may not want a divorce, the law says that I have to give a party a divorce if one side tells me this marriage cannot be repaired and judge, I want to move on. They don't even have to prove the other spouse did anything wrong. They just have to say, Judge, I want a divorce, and under the law, I have to grant that divorce. So, Ms. Beckford, I'll ask you one more time before I grant the divorce. Is there any hope that the two of you can go back living together as husband and wife?
No.
Okay. The court has heard the testimony, and I am granting the divorce. I am awarding Mr. Beckford his Chrysler 300, and I'm awarding Ms. Beckford her 2011 Hyundai. And then any other miscellaneous property that you all have, you're awarded to whatever's in your possession. So any bank accounts you have, any furniture, jewelry, that kind of stuff, each party is going to keep their own and pay any debts in their name. I want to thank you both for
Can
being
I
here
say
this
something?
morning. Mr. Beckford, I'm going to let you work. Yes, sir.
I just want to say this one thing. And God knows what I'm finna say. That by the end of the day, Judge, I appreciate you for letting me say this one thing to my wife, that I wish you nothing but the best. But the thing is, it could have been resolved. All these problems could have been resolved if you find it in your heart to forgive and stop with all this foolishness. And can walk away. But the thing is, ain't no one gonna love you like I did love you. And I appreciate you for all that you have done. Thank you, Judge.
All right, thank you, Mr. Beckford. Thank you, Ms. Beckford. I have signed the divorce decree. If y'all would like to get a copy of this decree, you can get it in the district clerk's office. I wish you two the best. All right, thank you all.
Thank you.
Thank you. Have a good one.
I'm sitting there asking questions, telling y'all you're muted, and I'm the one that's muted. Oh, good night. What I was going to ask y'all, I was just downloading your exhibits, and I wanted to know if it would help if y'all needed 2 or 3 minutes for me to put the lawyers in a breakout room to see if they can stipulate to some of the exhibits, because it might make the trial go a little quicker while I review your pleadings. Or have y'all already had an opportunity to do that?
Your Honor, we discussed exhibits. We agreed to pre-admit some of our exhibits, and then as a housekeeping matter, I am objecting to the inclusion of Mr. Zan's exhibits as they were not submitted timely per the local court rules.
Okay, all right, let me take a look at that. And I'm also going to review the pleadings. I'm going to bring the parties in, and we'll get started here shortly.
Thank you, Your Honor.
Okay, I was just telling the attorneys, was asking if they needed some time to go through the exhibits, but they've already done that. So I'm going to review your pleadings just real quickly. I've got all the exhibits downloaded, so we're just about ready to start. But just give the court a couple of minutes, and I'll come back on here and get on the record. All right, we're ready to get started when y'all get your videos up. The court's on the record in cause number 15 DCV 228547. It's a post-divorce division of property action filed by Mr. Groen, and Amy Groen is the respondent. Counsel, if you would please each identify yourselves and the party that you represent for the record.
Good morning, Your Honor. Alexandria Gwynn from Skilling Firm. I represent Clary Groen, the petitioner. I have Kathleen LaFair with me as well as co-counsel.
Good morning, Your Honor. Dean Zand. I represent the respondent, Amy Groen.
All right, any preliminary matters that we need to address from either side before we get started with the trial in this matter?
Your Honor, we have exhibits to pre-admit. my exhibits to pre-admit, and then I would just wanted a ruling on our objection to the exclusion of Mr. Zand's exhibits.
All right, let's take the stipulations first. What stipulations do we have as far as exhibits?
Your Honor, in regards to petitioner's exhibits, Respondents Council has agreed to P1, P3 through P11, and P15.
Mr. Zand, does that accurately reflect the agreement that you have with opposing counsel as far as petitioner's exhibits?
It does, Your Honor. Yes, Judge.
All right, and are you offering those exhibits at this time, Ms. Gwynn?
Yes, sure.
All right, so the court is admitting petitioners 1, petitioners 3 through 11, as well as petitioners 15. All right, let's take up the issue with respondents' exhibits, or do y'all want to just do that as they're offered?
Judge, we've got 4 exhibits. One is a tax return. The other is, let me pull them up as we're speaking, Judge. They were sent to opposing counsel on the court at 3:30 yesterday afternoon. I understand they weren't sent by noon. However, the court's policy says that it may result in exclusion. It's not a shall provision. And so I'm asking the court to consider that it's only 4 exhibits. It's not of any document that's a surprise to the opposing counsel. In fact, one of the exhibits is the beach escrow document, which her client has possession of and access to, along with the forbearance document related to the property, which her client has access and knowledge of. And the other 2 are my client's tax return and her pay stubs, Your Honor. That's about it. So I don't believe these constitute any surprise.
The court's going to rule on the exhibits as they're offered, but and we'll take that objection as them being untimely at that time. I'm not going to just exclude them until I know a little bit more about the case and what's presented on the petitioner's side. Anyone that's going to provide testimony today, if you would, please raise your right hand for me to be sworn. Do each of you solemnly swear or affirm the testimony you're going to give in this cause will be the truth, the whole truth, and nothing but the truth will help you God? Thank you. All right, Ms. Gwynn, you represent the petitioner, so you're going to be allowed to present your case first. Would y'all like to give brief openings, Ms. Gwynn?
Yes, Your Honor, if we may.
All right, you may proceed.
Good morning, Your Honor. This is a vacation property condo that was awarded to Ms. Groan, respondent, in the divorce decree, which was signed in 2016. The evidence is going to show that Ms. Groan was not only in control of all the bills and the information to pay the mortgage during the marriage, but she continued to be in control of the bills for the property she was awarded after the divorce decree was signed. The evidence is going to show that Ms. Groan timely paid this mortgage on the property, even though the divorce decree signed in 2016 failed to award the debt to Ms. Groan. It wasn't until the end of 2019 that a amended modification concerning the party's children was filed, and Ms. Groan unilaterally stopped paying the mortgage. At this time, there is an outstanding balance of over $30,000, and Mr. Groan's credit continues to suffer. We have tried to seek all reasonable remedies to not come to trial, and all efforts have failed. Ms. Groan is going to present evidence that she is destitute and without the funds to provide the monthly mortgage payment and to pay the outstanding mortgage. We are going to present evidence that that is actually not true and contrary to the belief. Your Honor, we're requesting that Ms. Groan be awarded all debt associated with the South Carolina property located at 801 South Ocean Boulevard, C-1 in North Myrtle Beach, South Carolina. We're asking that this be awarded retroactive to 2016. We're asking that Ms. Groan be ordered to sign a DOTSA today and pay off the outstanding balance owed no later than May 1st. And then we're also asking for the court to order that she either list the home for sale or the condo for sale within 30 days or refinance with a mortgage to remove Mr. Groan's name and to stop the damage that is being done. Thank you, Your Honor.
Thank you. Mr. Zan, would you like to give your opening at this time?
Yes, Your Honor. And Judge, Ms. Gwen is correct in that we are here today in regards to a division of debt that was not included in the final decree of divorce, Your Honor. That is in fact a debt associated with that vacation property, a condo in South Carolina. Your Honor, the property was awarded in fact to my client in the decree. However, the debt was not listed as a debt included in the divorce. And in fact, the payments were being made through the 2019 year, Your Honor. In fact, that is what Ms. Gwen stated, is that in 2019, there was a modification filed in which Ms. Growen's income was significantly decreased as a result of the modification. She was receiving prior to that modification spousal support and a higher amount of child support each month. Those were terminated. Post-divorce, Your Honor, my client has gone through 4 surgeries in 1 year. She's had a double nephrectomy, including a kidney transplant, Judge. So she's had severe health issues. Her income has been significantly decreased. Opposing counsel did bring up the fact that my client has access to funds. And yes, she has separate property, Your Honor. And here's the issue that the court's going to have to determine, Judge. We're not contesting whether or not this property should be awarded or this debt should be awarded to one of the parties, Judge. We could agree to that. It's how the debt should be paid. And I don't believe this court has the authority at this point in time other than to issue a just and right division of the debt or the asset in a post-decree division of debt or assets, Judge. And so here, Your Honor, the court can only, and it's our opinion, Judge, say which party is awarded this debt, not how the debt has to be paid, when the debt has to be paid. That's the issue that's going to be before you, Your Honor, because my client is living off minimal income, has separate property, which this court cannot divest her of. But however, that is all she has, Judge. That's what she's living off of. That's her nest egg. And so if this court does consider that she has significant separate property that she can pay this debt off with, Judge, you're basically liquidating her nest egg, her cushion to be able to move forward in life. And so that is the biggest issue that this court's going to have to address today, Judge. Not which party this debt is going to be awarded to, but how the debt, if the court determines it should be paid. And you're going to hear evidence, Judge, that this property is currently listed for sale and will be sold. There's currently a cash buyer, Judge, and you're going to hear evidence through Ms. Growen and I'm sure through Mr. Growen that the property is likely to be sold in no later than 60 days with the cash buyer that will pay off all debts and HOA fees that are in existence as of now, Judge. So we're here just to determine who's going to be awarded this debt, Judge. And if opposing counsel and her client are insistent that it has to be paid by a certain date or there's certain provisions that need to be included, I don't think that this court has that authority to do that. And so that's where we're left with, Your Honor, and you're making that decision today, Judge. Thank you.
All right, thank you. Ms. Gwen, you may call your first witness.
Your Honor, I call Clary Grown.
You may proceed.
Okay, thank you, Your Honor. Good morning. Can you please state your name for the record?
Clary Holmes Growen.
Okay. And can you please state your current residence?
At 6 10 Acre Walk in Missouri City, Texas.
Okay. And who is your former wife?
Amy Growen.
Okay. And when did you divorce?
August of 2016.
Okay. And did you enter into an agreement for a divorce?
Yes.
Okay. And was this done informally or formally?
It was through attorneys,
Okay.
formally.
And to clarify, did you have an attorney at the end of your divorce?
No, my attorney retired about a week to 2 weeks prior to the final judgment on the divorce.
Okay. And did you have property agreements in your divorce?
Yes.
Okay. And did you and Amy discuss these property agreements?
At length, yes.
Okay. And did you have lots of property divide?
We had 3, yes.
Okay. And in fact, were there properties in other states?
Yes.
Okay. And were you awarded certain property in other states as well?
Yes, I was awarded one in Georgia, and she was awarded the one in question in South Carolina.
Okay. And have you ever asked Amy to pay any of the debt associated with the Georgia property?
No.
Okay. And can you tell me the address of the South Carolina condo?
It's 801 South Ocean Boulevard in North Myrtle Beach, South Carolina.
Okay. And just to clarify, who was it awarded to?
Amy.
And then what debt is associated with that property?
There's just a traditional mortgage debt associated with that. And
Are there any other yearly fees that have to be paid?
there's a homeowners association fee that's required to be paid on a quarterly basis.
Okay. Are there taxes?
Yes.
Okay. And
Insurance.
okay. And was this debt associated with the property known at the time you entered into the decree?
Yes.
Okay. And was this debt discussed at all?
It was discussed in detail, and it was part of spreadsheets that we had back and forth that assigned this debt. And at the time, to ensure the fairness of the allocation of assets and debt, we had the property assessed, and the assessed value at the time was actually less than the debt. And so she got in effect a credit on these detailed spreadsheets that we put together, which you have, Alex, that shows this credit that she was awarded.
Okay. And so who sent you this Excel sheet?
This was a shared document that we sent back and forth on a regular basis.
And
during
Clary, when you say we, who are you talking about?
Amy.
Okay.
Mhm.
And so I want you to look at P2, and can you describe to me what it is?
Which one is P2?
You have the exhibits pulled up in front of you?
I do.
Okay, it should be the Excel sheet.
Is
Let me know when you see it. Do you see it, Clary?
I'm looking.
Okay.
Is it possible to share it on the screen quickly, or?
I need you to look at it first before I share it on the screen because it hasn't been amended. I'll email it to you.
Okay, I'm sorry, I have it.
Okay, what is P2?
So P2 is an asset inventory list, basically, that Amy and I shared back and forth on a weekly basis as we work through the division of our assets and
Okay.
debts.
And what does it reflect? Like, you basically answered it. So what does it reflect?
Well, it reflects, what the value of these assets were and how the assets as well as the debts would be distributed.
Okay, and did this reflect a just and right division?
Yes.
Okay, and did this reflect the division of property that went into your decree?
Yes.
Your Honor, did we lose the court reporter?
No,
Oh, okay.
the court's got taking this down on a record, so it's an
Okay.
electronic recording device. I think that was the bailiff's audio visual
Okay.
camera.
Sorry, Your Honor. I just wanted to double check. Okay. And so this was Clary, this was the agreement that was reflected in your decree, correct?
Correct.
Okay, and who sent you, you said you went back and forth, but who sent you this inventory?
Amy.
Okay. Your Honor, I would like to offer P2 into evidence.
Response, Mr. Zan, any objections?
Judge, it's a document prepared prior to the divorce decree being entered by this court, Judge. So I would object as to relevance, as well as the final decree of divorce apparently includes all the assets and debts that these parties were in discussion with. And so I don't believe that this is the most accurate and reflective agreement of the parties, Your Honor, outside of the final decree of divorce, which I understand we're here for today. However, I'm going to just object as to relevance, Your Honor.
And Your Honor,
Ms. Quinn, response to the
my response would be that it is entirely relevant to the intention of the parties. It's also aiding the court in what was considered a just and right division. And to respond to Mr. Zan about everything being included in the decree, it's actually not, and that's why we're here today. So it's a very important to show that it was an oversight and it's a just and right division, and this is what was contemplated.
Your Honor, may I say something, please?
No, Ms. Grine, you can't yet, ma'am.
Your lawyer is going to speak for you until it's your turn to testify. The objection to P2 is overruled. P2 is admitted.
And Clary, I'm just going to share the screen. And Clary, if you could just tell me where is the property? Can you just tell me like the number line that it's on?
That's the third line.
Okay. And can you tell me what does the red, I think you have a definition up in the corner. What are these values in each of your column representative of?
Yeah, so what's specific in regard to Myrtle Beach, what this shows is that at the time in 2016, when this was contemplated just prior to divorce, the property assessed value was $197,600.
Okay.
The debt from the mortgage debt at the time was $38,000 greater than that.
Okay.
So in effect, she was getting a credit of the difference in the property division because of that differential there. The value of the property was less than the debt.
Okay, and whose column is the Myrtle Beach in?
That's Amy's.
Okay, and did you rely on this inventory when you, as the division of property that was going into your divorce decree?
Yeah, I mean, this was the sole document that we shared. Amy and I shared back and forth on a regular basis to make sure that the property was divided fairly, and that we were abiding by this general percentage division of the assets that we had agreed to.
Okay, and was it the intent? What was the intent regarding the debt of the Myrtle Beach property?
Well, the intent was that she took the asset along with the debt, just as I, with the line item above, Oakland Drive, took that asset along with that debt. And I paid that debt, those taxes, those insurance payments since the decree was finalized. And she did the same with Myrtle Beach up until, for 3+ years, with no discussion about that debt, those payments, HOA fees, or anything of the sort. And this did not become an issue until she ceased paying those debts.
Okay, and who routinely paid the bills?
When we were married,
And after?
Judge, I'm gonna object as to relevance as to who paid the bills.
Sustain.
Did Amy have access to the mortgage information after your divorce?
yes,
Okay. And you touched on this earlier. Did she pay the mortgage on on the Myrtle Beach property after your divorce?
oh, for over 3 years, yes.
And without her paying the mortgage, is this division of property equitable?
Can you restate that?
Is this a just and right division without her paying the mortgage?
No.
And we touched on this again, so I'll be brief. There were other debts associated with the property, right?
I mean, there's annual HOA fees, insurance payments, taxes. Yes.
Okay, and were these paid?
Yes.
Okay. And do you believe Amy is capable of paying for the mortgage?
Yes.
Okay, do you believe she was capable last year to pay for the mortgage?
Yes.
Okay. Did she do anything to remedy the situation of non-payment last year?
No, when I learned of the non-payment through letters received from the mortgage company. I then investigated online the account to see what was happening, and saw, I think at the time I first noticed this or got the first letter, I think it was 2 or 3, maybe 2 months of non-payment. I brought this to her attention. She did not respond, and failed to respond to my inquiries about it over the subsequent few weeks until I was essentially backed into it.
At this point in time.
Sustain.
And Clary, just try to answer the questions I ask and I can follow up. So approximately how many times did you ask her to remedy this situation?
Objection, Your Honor. Relevance as to the question. I don't know how this has to go to the division of the debt.
Your Honor. Okay, are you aware of any health problems that Amy had during the last year?
Yes.
Okay, what were the health problems?
She had a kidney transplant year and a half ago, maybe. I'm not sure. She could give the specific date.
Did you seek out remedies with the mortgage company?
Yes.
Okay. And what were those remedies?
There are a variety of remedies that were options. One was obviously the payment of the debt that was outstanding. The second was their willingness to refinance with her directly. And all that information was provided to her.
Okay. And did you try to settle this issue out of court?
Yes.
Did you try to settle this issue with the debt before you had to incur attorney's fees?
Yes.
And what was Amy's response when you tried to settle it out of court?
Effectively, she wanted me to pay the outstanding debt and that it accumulated, and then assume the debt and the asset.
Okay. And were there options to refinance?
Yes.
Okay. Were these communicated to Amy?
Yes.
Okay. Pardon? By who? Sorry.
I did.
Okay, and what method?
Orally, through email.
And have you suffered any damages with this debt not being awarded to Amy?
Yes.
Okay. Can you very briefly describe the damages that have that you have occurred?
My credit rating has fallen to the point where I can't get an automobile loan, or I've been rejected for automobile loans. My credit is so poor now that I have to, we got a new electric provider and I had to put a deposit down of $200, which I've never had to do in my life. The reason being is provided from the electric, the utility provider was my credit rating was so poor.
Okay. And Clary, I'm gonna direct you to exhibit 12. If you could please pull it up on your computer.
In the interest of time, you may want to forward it to me in case I can't find it timely. You said 12?
Yes.
Yes.
Okay. Is this a record that was made at or near the time that your credit score occurred?
This was my credit score in November of 2019.
Okay. Was this made at or near November 19th, 2019?
Yes.
Okay. And is this document transmitted by you? Do you have personal knowledge of your credit score?
Yes.
Okay. And do you keep this credit score in the course of a regularly conducted business activity?
I'm sorry, you broke up. What was that?
Sorry. And do you keep your credit scores in the course of regularly conducted business activities for your personal records?
Yes.
Okay. And is it the regular practice of yourself to make and keep these records?
Yes.
Okay. Your Honor, I would like to offer P12.
Any objection?
Judge, I would object as to relevance. We're here to divide an asset, not regarding Mr. Clary's credit score as well as hearsay.
And Your Honor, I would respond. It's a hearsay exception 8036. I proved it up as a personal business record. It goes directly towards attorney's fees and the damages that my client has had to suffer after, reasonable settlement offers were rejected, and the expenses and attorney's fees he has had to incur because Ms. Groen did not assume this.
All right. The objection to P12 is overruled. P12 is admitted.
And Clary, I'm not going to put it up on the screen, but what was your credit score in 2019?
797.
Okay. And in the interest of time, Mr. Zan, I have P13, which is his 2021 credit score. Would you like me to prove it up as a business record as well?
Yes, same objection, which I know the court is gonna.
Yeah, the court's going to overrule the relevance objection, and so P13 is admitted.
Okay. And Clary, if you could just pull up P13 and let me know what your credit score is.
649.
Okay. And Your Honor, I would like to offer P13 as an exhibit.
P13 is admitted.
Okay. And Clary, you testified that this was a significant drop in your credit score, correct?
Yes.
Okay. To your knowledge, did your credit have to suffer like this?
No, no.
Okay. To your knowledge, is Amy in control of sufficient funds to pay this mortgage?
Yes.
Okay. And to your knowledge, what is Amy in possession of?
She has a sizable stock account as well as retirement accounts.
Okay. And do you with her current behavior, do you believe she has sufficient cash to also take this debt on and pay it off?
Yes.
Okay, and why do you think that?
Well, I know what the assets were, the cash assets that were awarded to her at the time of the divorce.
Okay, and has Amy gone on any trips recently?
Yes.
Okay, where did she go?
She took our two daughters to Orlando for a spring break
Okay, and when was that?
2 weeks ago.
And has she made any payments on the mortgage in the last month?
No.
Okay, and you heard that Mr. Zan talk about a selling of the condo, correct?
Yes.
Okay. Do you think this sale could potentially fall through?
Objection, Your Honor, cause for speculation.
Sustained.
Okay. Do you know who the buyer is?
I know of who the buyer is. I know about them. I don't know them.
Okay. Who are the buyers?
The buyer is a relative of people who also own in the same building.
Okay. And is any sale guaranteed?
No.
And are you okay with Amy selling the property?
Yes.
Okay. But are you requesting specific provisions be included in Judge Bell's ruling to protect yourself?
Yes.
Okay. And regarding this buyer, have you been provided with any proof of funds?
I've got nothing.
Okay. Okay. And our P1 was already admitted. It's your requested relief, Clary. And are you asking the court to award Amy the debt for the South Carolina property retroactive to the date of divorce?
Yes.
Okay. Are you asking her to be ordered to refinance or list the home by May 31st?
Yes.
Are you asking that Amy pay off any outstanding amount owed before May 31st?
Yes.
Okay. Are you asking her to sign a deed of trust to secure assumption?
Yes.
Okay. Did you incur attorney's fees?
Yes.
Okay. In your belief, did you have to incur the amount of attorney's fees that you incurred?
Not at all.
Okay. And do you know about how much you have incurred with our firm?
Greater than $10,000.
Okay. And would you have incurred those fees if Amy had paid the mortgage on the property she owned?
No.
And would you have incurred any of these fees if there was a reasonable offer made?
No.
Okay. And are you requesting Amy pay your attorney's fees as well?
Yes.
Okay. And one more question. When did Amy alert you that the property was being listed for sale?
Well, she didn't tell me it was listed for sale, but that she'd had conversation with these relatives, and that was probably 30 days ago or so.
And to your knowledge, were any efforts made by Amy to decrease the amount of damages you had to sustain in the last year?
No.
And when did you first contact her to pay the mortgage?
Probably March or so of 2020.
Okay. And sorry, I know I said last question, but just a few more. And did you actually try to put Amy in touch with the mortgage company directly?
Several times.
Okay. And what was her response?
Unwilling.
Okay. And did she give a reason for not willing to talk to the mortgage company?
Not that I recall.
Okay. Did she give any other reasons for her not paying the mortgage?
That she didn't have to.
Okay. Your Honor, pass the witness.
Mr. Zane, your witness.
Yes, thank you, Judge. I'll be very brief. Good morning, Mr. Groen.
Good morning.
Sir, your attorney had asked you if you had any communication with your ex-wife, Ms. Groen, concerning the debt that we're speaking of here today, the mortgage related to the South Carolina property, in regards to trying to resolve this. And you said that she wanted you to assume the debt and the asset. You remember stating that?
Yeah, that's what I recall. I think there was maybe an email response from you. And that's what I remembered from it.
So is it your understanding that to try to resolve this matter, your Ms. Groen had offered you the property as well as the debt?
That's what I recall, yes.
And you were unwilling to take the property or the debt, correct?
Correct.
All right. So what you're asking of this court today is that Ms. Groen be awarded the debt associated with the South Carolina property. However, you want additional provisions added in there that require her to do certain things by dates certain, correct?
Yes.
And in your understanding, has that been one of the points of contention between you and Ms. Groen regarding those provisions concerning when things have to take place or when amounts need to be paid?
To an extent, yes.
And you stated that you're in agreement that the South Carolina property be sold. You have no issue with that, correct?
Correct.
And so you also testified that Ms. Groen notified you approximately 30 days ago that she potentially had a buyer for the property. You're aware of who this potential buyer is, correct?
Correct.
And so if Ms. Groen is in the process of getting this property sold, would you be willing to sign any and all necessary documents to effectuate that sale?
Yes.
And I want to clarify some things with you. The mortgage is currently in your name alone, right?
Correct.
And so all the mortgage statements, any documents related to the mortgage that are sent out are sent to your residence and not Ms. Groen's, correct?
Correct.
And so the only way Ms. Groen has been provided any notice of any items related to this mortgage are through you.
Yes, and she's been given access to the account online as well.
That you provided her access to the account online as of recently, let's say in the last 30 days, correct?
I don't recall the timing. I think it was prior to that, but.
Let's say sometime in 2021, you provided her access online.
My recollection is it was last year, but.
So you don't recall exactly when you provided her access?
I couldn't tell you the month, the exact month.
Okay. Prior to the commencement of this suit, Mr. Groen, were you providing your wife a certain amount in spousal support as well as an additional amount or a different amount in child support?
Your Honor, I'm going to object as to relevance.
What's your relevance, Mr. Zan?
Judge, it goes to, they're saying that there was a time period in which Ms. Groen stopped making these payments, and that's our argument, Judge, is in correlation to the decrease in funds she was receiving.
All right,
You'll hear, I can get it through my client, Judge. I can get it through my client. So, Mr. Groen, I just want to clarify some things. You're asking that this court award the debt related to the South Carolina property to Ms. Groen. However, you want this court to order that either the property be sold by a date certain, which is May 1st.
Yes.
And are you aware that the potential buyers are asking for a 60-day close date on the purchase of this property?
I'm not aware of that, no.
Okay. Are you, and alternatively, you're asking this court to order that Ms. Groen, if the property is not sold, or are you asking in lieu of the property being sold that she make the mortgage payment or the debt associated with the mortgage current. I guess I'm confused a little bit on your requested relief.
Well, the debt needs to be made current, but there's concern about ongoing challenges. So it would need to be, in my opinion, refinanced in her name so that I'm not a party to this type of situation in the future.
So what specifically are you asking of this court then? Because you've got several prongs that you've asked for. What are you asking for, if you don't mind clarifying for me today?
Your Honor, I'm going to object. Our requested relief and our plea speak for itself.
Overruled.
You can answer the question, Mr. Groen.
The debt needs to be assigned and refinanced in her name if it's not sold.
So you would be okay if the property was sold. In any event the sale didn't go through, you're asking that this court order Ms. Groen to refinance the property?
Yes.
So that's what you're asking of this court today. Either sell the property or assign the debt to Ms. Groen and then either have the property sold, or if it's unable to be sold, Ms. Groen's ordered to refinance it?
Yes.
I pass the witness, Your Honor.
Ms. Gwynn, anything further?
Just a few questions, Your Honor. Your Honor, Mr. Groen, sorry. Mr. Zan asked you about access to the mortgage account. Can you clarify, have you tried to add Amy to the account previously?
She's been added to the account or added, accessibility to it and provided the phone number. I've offered to get on calls with her and the mortgage company. She's been provided the access, the username and password to the account.
And when did you provide this? Recently or last year?
Some things were provided last year. I don't remember what was provided on what date, but
Judge, I'm going to object as asked and answered. He previously testified, Your Honor, when I asked him, he says he doesn't recall when access was provided.
The objection's overruled. You addressed it, but Ms. Gwynn hasn't, and I'm going to give her an opportunity to address it.
And Clary, could you just restate what you just said? Sorry.
she was provided access to the mortgage company via phone, via access to the website and the account itself. On separate occasions over the course of the last several months.
Okay. And was one of those months as early as July of 2020?
I'm sure.
Okay. And was there a need for Amy to have the mailed in statement when she was timely paying the mortgage?
No.
And to be clear, when you received documents regarding the mortgage, did you give them to Amy?
Promptly.
Okay. And are you asking her to pay all of the debt on this property until it's sold?
Not necessarily if it's sold in a timely manner, but there.
Okay, Clary, if forbearance ends before the property is sold, are you asking her to timely pay the mortgage?
Yes, definitely. Yes.
And are you just asking for an enforceable order to stop the damage made to you?
Yes.
Okay. And to clarify, did you need to incur attorney's fees for any of this?
Judge, objection asked and answered.
Sustained.
And are you asking that attorney's fees be granted to you in the amount of approximately $12,500?
Yes.
Objection leading, Your Honor.
I'll allow it. What was it, the amount? 12,000 what?
500.
Thank you.
No further questions of this witness, Your Honor.
Mr. Zan?
No further questions, Your Honor.
Ms. Gwen, you may call your next witness.
Okay. Your Honor,
Oh,
we
and just
call,
for scheduling purposes, I was going to let y'all know, I have an 11:30 meeting, and it is a Zoom meeting, so I'm going to have to get off at 11:25. My hope is we'll be able to finish by then, but if not, we're going to do an early break for lunch, and then we'll come back early so that I don't interrupt y'all's afternoons. So we're going to work as quickly as we can to try to get through it, but I just wanted y'all to be aware I'm going to have to break about 11:25. All right, Ms. Gwen, you may call, or I'm sorry, Ms. Lefevre, you may call your next witness.
Thank you, Judge. I'm going to call Amy Groen. Ms. Groen, could you please state your name for the
You may
record?
proceed.
Amy Madeira Groen,
And could you please state your current address?
8833 Snowy Owl Loop, Missouri City, Texas, 77459.
And Ms. Groen, are you currently employed?
Yes, ma'am. With
By
Morgan
whom?
County.
Sorry, I'm having a hard time hearing you. Could you speak up, please?
I am employed as a paraprofessional in special education at Fort Bend County.
And with whom?
Fort Bend ISD as a paraprofessional in special education.
And what is your current gross income with Fort Bend ISD?
Less than $25,000 a year.
What is your income?
It's like 24 and some change.
Okay. And you were divorced August 31st, 2016, is that correct?
Yes, ma'am.
And in that divorce, you were represented by an attorney, isn't that correct?
Yes, ma'am.
And you and Clary went back and forth with property agreements via an Excel spreadsheet that's been admitted to the court, isn't that correct?
There was an Excel spreadsheet that had a bunch of different things on it, but it was not admitted into court. As
Objection non-responsive after there was an Excel spreadsheet.
Sustain.
And you signed a decree of divorce, isn't that correct?
I did.
And at that time, it was your understanding that you were awarded the South Carolina property, isn't that correct?
Yes, ma'am.
And at that time, it was also your understanding that you were awarded the associated debt, isn't that correct?
We had an agreement that he was going to pay me an additional.
Objection non-responsive.
Sustain.
It was your understanding that you were awarded the debt associated with the South Carolina property, isn't that correct?
I'm not. Can I answer with something other than a yes or no?
No, ma'am.
Your lawyer's going to get an opportunity, Ms. Groen,
Okay.
after you answer these questions from Ms. Lefevre, and if he thinks you need to explain one of your answers, he's going to make a note of that, and he'll address that with you. So right now, because you're being called as an adverse witness, Ms. Lefevre is allowed to lead you, which means she can ask you questions that call for a yes or no response. I need you to just answer the question that's asked and trust that your lawyer is going to bring up the information he thinks you need to explain. Okay? You may continue, Ms. Lefevre.
And so just to re-ask my question, Ms. Groen, you understood at the final decree of divorce that the debt associated with the South Carolina property was also awarded to you. Isn't that correct?
Yes, to an extent.
Objection after yes. Non-responsive after yes.
Overruled.
Okay. And so you paid timely on the mortgage, the taxes, and the insurance and the HOA for 3 years. Isn't that correct?
Yes.
And at the time of your divorce, you had kidney problems. Isn't that correct?
I did. I was in renal failure.
And so your health condition was present at the time of your decree of divorce, was it not?
Was.
And when you stopped paying the mortgage when was the last payment you made on the mortgage?
March 2019. 2019, I paid $500. I paid in full January of 2019. Did not pay February. I paid $500 in March.
And it was your understanding that you were awarded that debt. Why did you stop paying?
I had a significant reduction in income. And I had spent a lot of money in attorney fees for Clary to take me to court for custody of my 3 children.
And so you thought that it was okay to stop paying on a debt you owed because it wasn't in your name. Is that correct?
I did not have the funds. I was living
Objection,
in
non-responsive.
I did not have the funds.
Sorry, Judge.
Sustained.
So you thought it was okay to stop paying on that debt because it was not in your name. Isn't that correct?
No,
Did you communicate to Mr. Groen that you weren't going to pay the mortgage anymore?
I told him I was having financial.
Objection, non-responsive.
Sustained.
Did you tell Mr. Groen that you were not going to pay the mortgage anymore?
No,
When Mr. Groen reached out to you regarding your missed payment on the residence, you told him you weren't going to pay at that point, didn't you?
I did.
I'm sorry?
Yes,
And you claim that you didn't have the funds. However, do you acknowledge to this court that you have at that time over $700,000 in accounts?
I don't know.
You don't know that you have almost a $750,000 in bank accounts?
At the time, I don't know what my account balance is. I have money that's separate property, yes.
Objection, non-responsive.
Sustained after I don't know.
Ms. Groen, you realize that your divorce decree divided certain assets, correct?
Yes,
And that divided all of your assets that were in that decree regarding your bank accounts and Mr. Groen's bank accounts, correct?
yes,
But it did not address a debt. Isn't that correct?
yes,
And you understand that Mr. Groen is asking for a debt to be assigned, correct?
yes,
Okay. And so when you said that you didn't have an ability to pay, you were asking Mr. Groen to pay out of his separate property for the debt that was awarded that you understood was awarded to you. Do you understand that?
I asked him to take over the property.
Objection, non-responsive.
Sustained.
Do you understand that you were asking him to use his separate property to pay the debt on the asset awarded to you?
Yes,
Okay. So you only have an issue with separate property if it's your separate property. Is that correct?
yes, I guess.
Okay. So do you acknowledge to the court that you currently have over $600,000 in accounts in your name?
Yes,
So you have an ability to pay that mortgage when that mortgage comes out of forbearance in May. Isn't that correct?
yes,
And you have had the exclusive use and enjoyment of that residence since 2016. Isn't that correct?
yes,
When you stopped paying, there had not been any modification of child support or of spousal support. Isn't that correct?
we were in the middle of a court case.
Something had been filed, but there had been no modification. Isn't that correct?
That is correct.
And you stopped payment as retaliation for that modification, didn't you?
No,
Do you recall sending an email to Mr. Groen saying that once he paid you a certain amount of money, then you would discuss the beach?
I don't recall any emails, specific emails about.
And Mr. Groen contacted you requesting that you contact the mortgage company, didn't he?
Yes.
And initially you refused to do so, didn't you?
No, I talked to the mortgage company. I talked to Chase and then I talked to the company that took over the loan.
Have you had an opportunity to look at what's been marked as Exhibit P4?
No, I was sent the documents in Dropbox and the file's too big for me to open with a free account, a free Dropbox account. Like
Your
this.
Honor, at this point, I either need to be able to publish or Mr. Zan's going to have to do something to be able to get that to his client since I can't communicate directly with her.
P4 has already been admitted.
It has been admitted? Okay.
Yeah.
All right, then I'm going to post. Sorry, that's not marked on mine. I'm going to share this really quick. Do you recognize this document now that you've seen it?
Yes.
Do you recall telling Mr. Groen that you would not move forward with the Bayview issue until after you settled the modification case?
Yes.
So you refused to cooperate with anything with regard to the mortgage and the division of property issue until the modification was complete. Do you recall that now?
Yes.
And do you recall that Mr. Groen reached out to you in February stating that the mortgage company had changed?
I do. I didn't know it had changed, and that's why the mortgage was not paid in December. I actually have an email from him to not pay the mortgage.
Did you provide that to your attorney?
No, I can
Provide that to the court today?
I can provide it to the court, sure.
What reason would Mr. Groen have given you to not pay a mortgage payment on a debt that he is since bringing you to court over?
Because the mortgage had been sold and he didn't know who it was sold to.
So he didn't ask you to not pay it. He asked
Yes, he
you
did
to make
ask
sure
me
it's
not
the
to
right
pay it.
place.
He asked me not to pay it.
He asked you to pay to the new mortgage holder. Isn't that correct?
No, ma'am. He didn't know who the mortgage was with.
So
Not pay the
the
mortgage.
email that I just produced, that you two went back and forth about who Bayview was and whether or not they were a mortgage finance company, and you claimed that they were
They're a debt collector.
You claimed that they were a debt collector, and Mr. Groen was going back and forth with you explaining that they're not a collections agency, but a full service loan company.
They are not a full service loan company. They are. a debt
Objection non-responsive.
Same.
Have you since seen the documents from Bayview Mortgage that have been provided and admitted to the court?
I have seen them.
Okay, so do you acknowledge now that Bayview is in fact a mortgage service company?
Judge, I'm going to object just to relevance. What is whether Bayview Mortgage Company is a debt collector or a mortgage holder? It really has no bearing on the associated debt. We're in agreement that the mortgage holder has the debt, which is currently Bayview, Judge.
It's actually, they've changed name. It's Community Loan Servicing, and they are.
Hold on. There's
debt
an
collector.
objection on the floor. Ms. LaFever, response to the relevance objection.
Your Honor, she's saying that she was told not to pay it. She was told that it wasn't, or that she's saying it wasn't the mortgage company. And I think we need to be clear that it is in fact the mortgage company and that she was aware of that.
The objection sustained is relevance.
Have you explored refinancing of that mortgage?
Yes, ma'am.
Is that available to you?
No. I cannot, the loan, I do not have the income.
Objection non-responsive after no.
Sustained after no.
Do you? No. Okay. Oh. You have an account with TD Ameritrade, isn't that correct?
Do. Yes.
And you have 6 accounts with TD Ameritrade, isn't that correct?
Yes.
And those accounts end in 313, is that correct?
Judge, I'm going to object as to the relevance of her accounts.
I'm going to lay the predicate, Your Honor. They've objected to our business records affidavit to the TD Ameritrade accounts.
Which exhibit are you talking about?
I'll offer P14, Your Honor.
Oh, you're laying the predicate for P14? Is that
Yes,
what
Your
you're
Honor.
doing?
But I'll go ahead and offer it. There is a
Objections over?
business records affidavit.
All right, any objections to P14, Mr. Zan?
Yes, Judge, relevance. These are my client's separate property accounts, Judge. They have no relevance here today on the division of a debt.
It absolutely goes to her ability to pay both the debt and attorney's fees, Your Honor.
All right, the objection to P14 is overruled.
Go ahead and
P14 is admitted.
Thank you, Judge.
Judge, I'm going to object. They have not laid the proper predicate. They can't just offer an exhibit without laying the predicate. I'm objecting. I don't understand how that's admitted.
If your only objection, is your only objection relevance? Do you have
Well,
other
in the fact,
objections?
if they're trying to offer the exhibit or if they're trying to ask her questions to prove it up, I don't understand what's happening at this point. I think she was saying that she wants to offer to lay the predicate to prove it up. And I'm just objecting across the board as to the admission of any exhibit at this time.
Okay, all right, lay the predicate, please, Ms. Lefevre, for P14.
Okay, you have 6 exhibits. They end in 313. Is that correct? Ms. Groen?
I'm sorry, can you say that again, please?
You have accounts that end in 313. Is that correct with TD Ameritrade?
Yes.
763. Is that correct?
Yes.
162.
Yes.
344.
Yes.
And 761.
Yes.
Okay. And at this point, I'll go ahead and offer exhibit P14, Your Honor.
Judge, I'm going to object. The failure to lay the proper predicate. There was no identification of what the exhibit is, Your Honor. And I'm going to object again as to relevance.
Those have already been established with the business records affidavit. She doesn't need to authenticate.
So the business records affidavit's been on file timely?
Yes, Your Honor. It's in the
Can you tell me when the business record affidavit was
filed?
filed?
There was a business record affidavit filed 12/14 of 2020 dealing with TD Ameritrade. It's 2,700 pages of records.
There's one
Are
also
these-
filed March 23rd, Your Honor.
I'm going to object to any business record filed March 23rd, judges. That's not timely. That's less than 30 days of trial.
30 days is not required for a business records affidavit, Your Honor.
Any other objections, Mr. Zan?
Relevance, Your Honor. Once again, these are my client's separate property accounts. I don't know how they have any relevance related to a division of a debt.
Well, there's a request for attorney's fees as well. So I'm going to overrule the relevance objection. How are these labeled, Ms. Lefevre? Is it just P14 or is it P14 and subparts?
So P14 is the complete record, Your Honor. Because it is voluminous, we have P14A through 14F, which are broken out. I would offer 14A through F. However, if Mr. Zan is objecting to completeness, then I will offer all of 14.
Mr. Zan, I understand you have a relevance objection. The court's overruling the relevance objection. Do you have any objection to just offering A through F rather than the full 2,700 plus
No,
pages?
Judge. No.
Right. Petitioners 14, A, B, C, D, E, and F are admitted.
Thank you, Judge. Ms. Groen, you were offered by Mr. Groen to take the debt when you missed the payment in 2019. Is that correct?
Sorry, can you repeat that?
Mr. Groen asked you to take the debt in 2019 when you began missing payments on the mortgage. Is that correct?
No,
No.
not that I recall, no.
You don't recall telling Mr. Groen that he could take the condo?
Not in 2019, I don't think.
In 2019, did you tell Mr. Groen you couldn't pay it because you were physically unable?
Yes.
And at that time, you had sufficient assets available to you to pay that mortgage. Isn't that correct?
Yes.
Mr. Groen was awarded a property in Georgia in the final decree of divorce, wasn't he?
Are you talking to me?
Yes.
Yes.
And has he ever asked you to pay that mortgage?
No, ma'am.
And you were awarded a residence in addition to the South Carolina property, weren't you?
Yes.
And you pay the taxes for that, don't you?
Yes.
And you were awarded a vehicle as well, weren't you?
Judge, objection as to relevance as to what she was awarded in the final decree.
Sustained.
If the home is not sold by the time that the mortgage is due again, do you agree to pay the outstanding balance until the home is sold or the mortgage is paid off?
No.
Pass the witness, Your Honor.
All right, Mr. Zan, your witness.
Judge, do you want me to start now, knowing that we have 5 minutes left? If you've got to leave around 11:20, Judge, or 4 minutes?
We have 9 minutes, so we might as well get into some of the testimony.
All right, Judge.
You may proceed.
Thank you, Your Honor. Ms. Groen, you testified earlier that you currently work for Fort Bend ISD, and can you tell the court once again what your income is?
Like $24,000 and some change.
And you told the court that you've attempted to refinance the South Carolina property, and can you tell the court what attempts you've made in regards to that?
I applied for a refinance in September of 2018 and was denied due to income. I was not.
Objection here, sir.
Sustained. Don't tell me what the mortgage company told you or
Yes, I have talked to, I have applied for a refinance and was denied.
Do you know what the basis for the denial is?
Low credit score and.
Objection, hearsay.
Sustained.
What is your current credit score, Ms. Groen, if you know?
Yeah, hold on. It's like 600 something.
Objection, hearsay.
Overruled.
I can look on Experian.
Don't do that right now. Mr. Zane, you may ask your next question. If you don't know,
If you don't know it, then don't answer it, or just say I don't know it at this time. You've heard opposing counsel bring up this issue with your separate property accounts and the funds that you have available to you. You testified that you have approximately $600,000 in accounts in your name, correct?
Yes.
Can you tell the court what your health situation was post-divorce and is as of now?
I had a renal failure from a inherited kidney disease and was in renal failure when we got divorced. Went pretty downhill after that. Had a couple minor surgeries, then a double nephrectomy.
Objection, non-responsive.
Kidney transplant.
overruled. You may continue, Ms. Graham.
I had a double nephrectomy in 2018, May of 2018, and then a kidney transplant in July of 2018, followed by a rejection.
Are you currently on any anti-rejection treatment?
I am.
And can you tell the court what your monthly average health care costs are, if you know?
I have insurance through Fort Bend ISD, and it comes out of my paycheck. I'd have to look at my pay stub, but I also have Medicare, which I pay $148 a month for.
Okay. So have these health issues caused you additional expenses throughout since the date of divorce up until now?
Objection, relevance.
Overruled.
You can answer the question, Ms. Groen.
Yes.
And this $600,000 you testified to with opposing counsel that you currently have, do you have any other funds available to you?
I have some inherited IRAs from my parents.
Why are these funds so important to you?
Objection, relevance.
Overruled.
Well, it's all I have.
Objection, unclear.
I don't have,
Overruled.
I'm not contributing to any 401ks or any kind of retirement funds. It's all I have to live on for the rest of my life. And I'm trying not to be a financial burden to our 3 kids. I've had tremendous medical expenses, and I am trying to keep prepared for the future should I have further complications with renal failure, and if I would ever need to be hospitalized again or put in a nursing home.
Was there a period of time that you were unemployed?
Objection, relevance.
Until
Sustained.
I was unemployed.
Mrs. Groen, you can't answer the question.
Oh, okay.
At the time that you stated earlier, or opposing counsel asked you when you made your last payment, and you said March of 2019, and you made a $500 payment. Do you remember that testimony?
Yes.
Can you tell the court why at that time the payment stopped?
2019 is when, March of 2019 is when my income reduced $900 a month from child support.
And what was that a result of?
Custody case where Clary
Objection, relevance.
my 3 kids.
Oh, hold on. Overruled. You may continue, ma'am.
Clary had served me in between my 2 surgeries for custody of our 3 kids.
And as a result of that lawsuit, your child support income decreased $900 per month?
Yes, sir.
As of today, based on what your current income is, can you afford to pay the monthly mortgage associated with the property in question?
No, not off my income and what I receive. I try to stay within my means and not have to dip into my
Objection,
retirement.
non-responsive after no.
Okay.
What, can you tell the court why you don't want to use those separate property funds that opposing counsel has questioned you about?
I fear.
Objection asked and answered.
I think I've heard that. Sustained.
When were you provided online access to the mortgage information?
I had access to the mortgage information earlier, but I didn't have permission to talk to the mortgage company until March 14th of 2021. A copy of the letter that Clary hand wrote and sent to the mortgage company to give me permission.
Objection, you're saying.
Overruled.
Do you know the current status of the mortgage as of today?
Yes,
Is it in forbearance, if you know?
it is until May 31st, 2021.
Okay. And what is the current situation regarding a possible sale with the property? Can you tell the court that?
I have received an earnest money check and a verbal agreement with a party that owns 2 other condos in the unit. We are waiting to finalize the sales contract. When I get the title work, the loan payoff information from the mortgage company and the balance on the HOA.
So have you agreed to an amount for the sale of the condo yet?
It's roughly $235,000.
Objection, non-responsive.
Sustained. He's just asking if you haven't reached an agreement on the value, not what it is.
Yes.
And can you tell the court what that amount is, if you know?
$235,000.
And why 235,000?
Amount to cover the debt, the mortgage balance and the HOA balance.
Have there been complications with this property since you were awarded it post-divorce decree?
Objection,
Yes.
leading.
Sustained.
Can you tell the court if you know of any issues with this property?
Yes.
What are the issues?
There is some structural issues with the underneath of the building where the moisture is coming up into the condo.
Objection, you're saying.
Sustained. All right, this is a good time for us to go ahead and break for lunch. I'm assuming we have about 30 minutes left. Is that, y'all think that's?
Judge, 15 minutes, maybe at most on my end.
Okay, and then we're going to have a brief redirect. So my guess is we should be done within 30 minutes. I'm just not sure how long this meeting's going to take me. So why don't we, let's resume at 1 o'clock and we'll finish up at 1 o'clock. We're going off the record.